Hi, I'm John McGowan. I'm General Secretary of the Social Workers Union. Good evening and welcome to another SWU webinar where social workers get the opportunity to ask employment-based questions. In fact, it's great once more to see so many people registered, and looking to my screen I can see a large number of attendees for tonight, which is terrific really, because I think there's an important football game on. I'm sure there is anyway, but so thank you for attending. I'm hopeful that we will get through a lot of questions this evening. And do remember that the advice offered for this session is as today's date, which is the 7th of July 2021. The event is being recorded and it will be available to review and share very soon. Working behind the scenes are the talented and skilled. There's Sean, there's Jane and there's Lisa. So on behalf of SWU, thank you very much. I will now take you through some of the housekeeping for this webinar. Please ask any questions in the live chat box, which is to the right of the screen, and Sean and Lisa will make me aware of them to share with the panel. My advice is always to keep the comments brief as possible, generic and non-identification factors in any message to represent confidentiality. Before I introduce the panel, I just want to emphasise the need to join a trade union. I'm biased. I would always recommend the only specialist social work union, which of course is SWU, and SWU working with BASWA is indeed a terrific collaboration for the entire social work community in the UK. And in particular, I'm delighted that we have now reached a 10-year history. That's a 10-year history from SWU, with a starting point of no members in 2011 to nearly 15,000 members in 2021. Why would you not want to join a specialist union? Now over to the most important people in this webinar, and I'll ask each panel member to introduce themselves. So we'll start with Paul. Paul, would you like to introduce yourself?
Thanks, John. My name is Paul Scoley. I'm a partner at trade union law firm Morrish Solicitors. We're based in Yorkshire, but we act for trade unions up and down the country, all over the UK. And we're very proud to have been acting for SWU and its members for 4 or 5 years now, John, I guess.
Yep, definitely.
Thank you all for attending and listening tonight on a night when there are other things to be done. I hope we can be of interest and informative to you tonight.
Thank you, Paul. And over to you, Laura, just to introduce yourself.
Hello there. Yeah, I'm Laura Sheridan. I'm one of our advice and representation team, trade union official, and yeah, I've been working for SWU and BASWA for 3 years now.
Thank you, Laura. And we will finish before 7 o'clock. So if you stay with us, we'll guarantee we'll finish before then. And I'm looking at the questions in already. So thank you very much for submitting the questions. Paul, I'm going to start with a very topical one, actually. It's regarding COVID-19. And the question is, can my employer assist on vaccinations? If I refuse, can I be excluded from work without pay? So if you don't mind starting on that one, thanks, Paul.
Yeah, thanks, John. That's the question on everybody's lips at present. What is the position in relation to the employer that says, if you don't have a vaccination, then you can't work, or I won't pay you if you don't come into work and you're not vaccinated? And the answer, I think at present, the only fair answer is we don't entirely know. This is new law. There have been, I don't know, 20 or 30 different questions that have cropped up in the last 18 months for me, after over 30 years giving employment law advice, that have been curveballs, because we've never quite seen them before, because we've never, certainly in my lifetime, had a pandemic quite like this before. But I'm not going to dodge the question. I'll take a view, and it's this, that we know already that the government has been vocal in the last few weeks saying that England care home staff are going to have the COVID vaccine. So that's going to be a legal requirement. If it's not already, then in the very near future, and that's not entirely surprising given the problems that arose at the beginning of the pandemic in the care sector. And we've already had a High Court judge who was asked to make a decision on behalf of a person who didn't have capacity to make their own decision about a vaccine, so a care home resident, and the judge took the view that the resident should have the vaccine, whatever the objections of family and friends, because of the issues that had arisen in the care home sector. So it's not surprising there that we're seeing a compulsory approach by government, and my suspicion is that that will certainly extend to the healthcare sector in general, and I think it will also extend to other parts of the economy where people are particularly exposed to risks because of COVID. And one of those, which might seem slightly off the wall, but which I'll raise because I'm involved in advising about quite a lot of it, is in relation to musicians. So my firm acts for the Musicians Union, who described to me the flute as a weapon of mass destruction in terms of COVID, because of the amount of spittle that can be created by a flautist. And of course, one can imagine that an orchestra will find it difficult to operate unless it can do so in rehearsal spaces that might be limited. So they're going to be close together, they're going to be playing instruments, or if there's a choir involved, singing in a way that's likely to result in an aerosol effect that could make COVID more transmissible. So not just the healthcare and care sector, but I think the music sector, and I think you can then extrapolate from that and say there are a whole set of sectors where, for whatever reasons, it's going to be increasingly important to ensure that people are double jabbed before they turn up at work. And I think certainly in those sectors, employers are going to be able to say, with some compulsion, we need you to be vaccinated before we let you in. I'm going to add some caveats there. There are certain employments where it's not going to be necessary. There are certainly people who have, for example, disabilities where vaccines are contraindicated, where employers are going to have to take very careful steps to ensure that they're not guilty of disability discrimination. It's even suggested by some that discrimination on the grounds of religion and belief might be invoked by people who have a philosophical opposition, if you like, to vaccines, to claim discrimination if they're faced with this sort of insistence by an employer. Personally, I think that'll be a hard ball to run with. Disability discrimination, yes. Religion and belief, probably no. So there we go. Those are my views generally. I think in certain sectors, yes, we'll find employers can insist. In others, it'll be more difficult. My personal guess is, and perhaps that betrays my own views about it, but my guess is that tribunals and courts will be kind of pro-vax on the issue. I think they'll say the science is behind it. It's difficult to criticize an employer who says do it, but every case will be fact sensitive, and every case will have to be looked at in some detail, which is my typical lawyer's get out of trying not to give too wide an answer to the question. So a lot to say there. Sorry that I've gone about it, but it's a huge question, and I guess I'd already touched around the edges of it.
No, thank you, Paul, and that was well expanded. Is there anything you would like to add to that answer, Laura?
Just a brief point, really. Well, a couple of brief points. I think firstly, Paul's very right. It's very, we can suspect how the courts will view it, but we don't have much in terms of case law or anything in terms of case law, and it is going to be that will guide us in terms of how the courts will view it moving forward. Although, you know, evidence would suggest that they are going to be erring on the side of vaccination based on the science. The other thing with regards to the discrimination side of things, there is always under the Equality Act the potential get-out clause for employers, which is that they can have policies in place that potentially discriminate if it is a proportionate means of achieving a legitimate aim, is the quote from the Equality Act. And in this particular situation, an employer is likely to argue, actually, we're going out, we're visiting vulnerable people, we need our team vaccinated, you know, to protect those vulnerable people. Potentially a proportionate means of achieving a legitimate aim under the Equality Act, but ultimately the courts will decide.
Perfect. So thank you, Laura, and I'll stay with you, Laura, for there's a couple of questions have came in and they're quite on a similar topic. I'll go quite slow with this one. It says, I have a health condition that makes me exempt from wearing a face mask. My employer is insisting that I wear one when I'm in the office, and he has said that if I don't, they will have to offer me an alternative job. So can they do this? And I'll come back to the second one if you want me to repeat it. But it says that the person says, I'm medically exempt from face masks, and the local authority I work for has banned me from home visits and access to the office, despite occupational health recommendations that I should access the office, and government guidance states that PPE is not necessary for home visits. So are you happy to tackle the two parts? So
I will go through to the first one first, John, and I may need to ask you to repeat the second one, but hopefully I've got the gist of that. I mean, in terms of the first one, these things are always very difficult, again, because we don't have the case law in terms of how it will be viewed. But to me, that there is a whole host of issues in terms of the first issue with an employer effectively saying because you can't wear a face mask, you've not got a job anymore. There are the employer does have a duty under the Equality Act when someone has a health condition, which could potentially be a disability in this case. And again, I don't know the details, but if there is a condition that could be classed as a disability, they have a duty to look at potential reasonable adjustments in that case. In this case, I don't know how the office is set out. Is there a separate area where somebody could, you know, be seated or be aware, so they're away from other staff members who are going to be, you know, more reluctant about spending that time in the office with someone if they don't have a mask on? Could this person not work from home indefinitely? Because let's be honest, we've been working from home for all this time, so why do we not do this for a little bit longer? So it's about exploring that more with the person, I think, and actually looking at what has the employer explored in terms of alternatives to keep that person in their job. To simply say you don't have a job if you don't wear a mask without looking at that further does feel unreasonable, and I'm not sure that that would be viewed as acceptable if there was a potential discrimination, you know, disability discrimination case there. But we would need to explore that, I think, a bit more with that person to get the details of that particular situation.
No.
With regards to the other situation, again, it's a little bit of a tricky one because a lot of the questions we've answered over the last year or so in our A&R team are employers that have actually been insisting people go out when they don't want to or are feeling comfortable to. But this is clearly somebody who is happy to go out and do those visits, and the employer are almost saying, no, we're not happy because of the health and safety issue here. Again, it would need exploring further. What is the occupational health report saying? Can this person not access the office and again have a separate area? In terms of the PPE going out on home visits, who are these home visits going out to? Because the employer is going to have to think about what the actual people being visited are going to feel about wearing a mask. If you've got someone who you're going out to is vulnerable or clinically vulnerable, they're probably going to want that social worker to be wearing a mask. So they're going to have to balance those issues as well. But it's all about exploring that and having that communication and dialogue with the manager and the employer about that. And I would strongly advise that somebody get some particular advice on that from our team and contact us, because I think it's really important that that's explored in terms of how that can be looked at more constructively with the employer moving forwards.
Perfect. That's answered there, Laura. Is there anything you'd like to add to that, Paul?
I agree with everything Laura said. I guess I'd add this, that in relation to home visits, the question then becomes not only what is the duty of care that the employer owes to the employee who's going on the home visit, but what's the position in relation to the people who are being visited. And certainly I think some people at least expect those visiting them, be they Amazon delivery people or whatever, to be masked. And so that expectation is something that the employer, I think, has to be entitled to take into account. But that doesn't mean that they can simply take a black and white view about it. I think Laura's right. Have the discussion, give advice about it, tackle the employer to say, is there a way we can work together to make this work? And that sort of dialogue is the way that perhaps both sides can work it out in a satisfactory way.
Thank you, Paul, and thank you, Laura. And of course, if you are a SWU member, you can expand on some of the questions if you want to answer it further with part of the duty call. If you're not a member, my question is why not? But you could always join; you still get the advice. So we've had a few questions in, which is quite good. We've had a couple of questions in from students, so thanks for your support, and we'll maybe look at them as part of the running order. And the question we're moving on to at the moment is the question that's just been in, and again, it's quite a topical question. And Paul, if you don't mind answering this, it says, does discrimination law extend to trans people? Am I protected if I have had no gender reassignment treatment? So again, it says, does discrimination law extend to trans people? Am I protected if I have had no gender reassignment treatment?
Thanks, John. That's a topical question. It's particularly topical today, I think, because I understand that that BSWU have issued a position statement on social work with trans people, and that's available online as of literally, I think, this evening. I should make it clear that that's not a SWU statement, it's a BSWU statement, but I'm sure people will want to refer to it. It's interesting also because there's been an in parts at least controversial decision in the Employment Appeal Tribunal in the last few weeks, upholding the claim in part of an employee who insisted that their right to believe in the fact that biological sex and gender were entirely separate and defined, if you like, things, so that it's been in the news too. But the short point is that, in fact, trans people are protected in the same way as any other person with a protected characteristic is protected. So the protected characteristics include sex and race, disability, of course, marital status, religion and belief, sexual orientation, and so on. But they include, in addition, people undergoing or planning to undergo gender reassignment. There was a time when it was thought that that might mean that trans people were only protected if they had taken some medical steps towards gender reassignment. It's now clear that that's not the case, and the Equality Act covers people who are undergoing or propose to undergo or have undergone a process or part of any process sex reassignment. So in short, trans people are protected in the same way that other people with protected characteristics are protected, and they need not have undergone any sort of treatment or surgery or medical intervention. They can identify as trans, and that is sufficient to attract the protection of the law. And the law, in fact, goes a bit further than that, and one is protected for perception in relation to trans status. So a person who's not in fact trans, but who is perceived as trans and is then discriminated against, is protected too. And we also now have associative discrimination. So you can be discriminated against because of your association with people who are trans. So there's no distinction now, in general terms, between trans people and any other protected characteristic. So the usual sorts of discrimination are covered: direct discrimination, indirect discrimination, harassment and victimization. I think some of those things in relation to trans people are not immediately obvious in the same way they might be in relation to some of the other protected characteristics that we deal with as lawyers. So online, just looking today, some of the examples given here is that it might be indirect discrimination if an employer has a dress code that involves wearing a uniform that is tight-fitting, because that might give a trans employee difficulty giving the appearance of being the gender with which they identify. Another example would be an employer running an icebreaker or a quiz at work saying, can people bring childhood photographs, on the basis that people can guess who's who, and that might then lead to a trans employee feeling excluded about that. Harassment, of course, would include dead naming and the like. So the short answer to the point is yes, trans people are protected fully under discrimination law.
Thank you, Paul. And Laura, was there anything you'd want to add to that?
I think Paul's answered that very fully. I think just as a point to say from my own perspective and from the perspective of our team, we would, if there was a trans person who believed or was suffering any form of discrimination in work or having any kind of difficulties, I would urge them please to get in touch with our team. We would 100% support that person to challenge that discrimination. You know, we would 100% oppose that discrimination and do everything we could to support that person to challenge it and get the right outcome.
Thank you, Laura. And I'll stay with you for we're really getting through the questions, which is great. There's a couple of other questions came in. We'll do our best to get back to them. One member's been asking about SWU and BASWR, how we're planning and advocating for social workers to challenge current work environments. Well, I think it just takes a bit of time maybe to look at the webpage to see the activity of BASWR and SWU, particularly around the working conditions campaign and around the BASWR England 80/20 campaign. And there's lots of other work going on. So if you are a member, sign up to a branch, be active. If you're not a member, then then sign up and have a look to see what BASWR and SWU are doing to create better working conditions. So thank you. So number 4, Laura, this one's about conditions in the contract. It says, my employer has put a condition in my contract that prevents me from working for other competitors for a year after I leave employment with them. Is this allowed?
Yeah, this is an interesting one, and it's one that our team have had come up a few times over the last few years, really. So what that is what's known in law as a restrictive covenant. They tend to have come up with regards to social work in private fostering organisations. And if you're working for a private organisation, as opposed to, we haven't seen it come up in local authorities. And what the reason employers put that covenant in is to effectively stop a person leaving, going over to another private organisation and effectively taking that business with them. So maybe taking, if you're working with foster carers, recruiting foster carers, taking them with them. It's about protecting the business, essentially. A lot of the time, the people I've spoken to, in fact, I think every time, have had no awareness of the fact that that's been in their contract until they've gone to leave, and then it's been pointed out to them. So the first piece of advice I will give anybody is, before you sign a contract, check it all the way through. And I'm sitting there saying that, and I'm sure I know I've been guilty of not thoroughly checking my contracts when I've been offered a job before, because you're obviously pleased about being offered a job and you sign your contract and off you go. But the one big piece of advice I would say is check what's in that contract before you sign it. In terms of them being allowed or being legal, yes, they are. They actually don't tend to fall under employment tribunal jurisdiction. That they fall under civil law. So what can happen is if you do breach that term, so quite often there's a term that prevents you working for a competitor for 6 months to a year, for example. The employer, if they choose to, can enforce, go to court and apply for that to be enforced, so you're not able to go and work for that competitor, or potentially sue you for breach of contract. Having said that, it's not quite that straightforward, because the courts do look at actually what is reasonable in terms of a restricted covenant being put in place. Generally, covenants that are over 6 months in terms of being able to go to work for a competitor are viewed as unreasonable, although it would depend on the individual business and circumstances. But previous case law has looked at that, and actually a lot of it would be about how much business involvement you have, how likely you are going to be able to go elsewhere and steal that business from the employer that you're working for. So it's not as straightforward as, yes, they're allowed, they can sue you for breach of contract. It really needs looking at in terms of, if your employer gives you a clause to say that you can't work anywhere for a competitor for the next 2 years, potentially that's going to be viewed as unreasonable by the court. So we would really need to look at actually what those clauses are and whether or not they would be reasonable. So if that is something that you're experiencing, please get in touch for our team to look at that with you further, really.
Thank you, Laura. And Paul, anything to add to that regarding the contract?
Yeah, we regularly come across restrictive covenants in contracts of employment. I'm not familiar with them, in fairness, in the social work field, and it's actually slightly surprising to me that that's somewhere where we'd find them. But I spoke to Laura previously about this, and it's obvious that you've got some experience of dealing with these cases. That the starting point legally is that if you seek to prevent somebody from practicing their trade or profession, then the law will say you can't do that. It's known as a restraint of trade, and the courts historically have prevented that sort of activity. Anecdotally and historically, of course, trade unions were originally banned because they were seen as a restraint of trade. Their effect on business was to make it harder to be in business, and that was the legal basis under which trade unions found it hard to exist 200 years ago. But in relation to restrictions, I'd just say this: they tend to fall into two camps. Those where the employer says, don't pinch our business. And courts are likely, or more likely, to uphold that sort of restriction, provided, as Laura says, that it's not for too long a period. But the other version of a restriction is an anti-compete restriction, as we call it, which is don't go and work in this sector at all for 6 months. And the courts are much more reluctant to prevent you working at all than they are to protect, if you like, an employer's goodwill or business base. So really technical stuff, really difficult. I'd advise always getting some advice from A&R about it before taking a view. Even what looks like a straightforward restrictive covenant in a contract of employment can be anything but.
Thank you, Paul. So many questions coming through, which is great. So we'll move on to question 5 now, and it's about whistleblowing. And I'll stay with you, Paul, if you don't mind. It says, whistleblowing, what sorts of statements are protected, and what is the right way to go about making a protected disclosure? Can this person go to the press?
Thanks, John. So the first thing to say is that not everything that you say to your employer that is critical or controversial is going to be covered by what's called the public interest disclosure rules, commonly known as whistleblowing. The principal types of disclosure that are likely to be covered are highlighting unlawful activities in an organisation, failing to comply with legal obligations, miscarriages of justice, environmental issues, and risks to health and safety. So one of the things that we're seeing now coming through in the tribunals with a bit of regularity are COVID-related whistleblowing cases where individuals have said to their employers, I don't think that you're dealing with the flu issues properly. And plainly, from what I've said, since that relates to the health and safety of individuals, it's potentially a protected disclosure. But the law isn't only concerned with the type of disclosure that you make. There's a second criterion, and that's how you make the disclosure. And what's commonly forgotten is that the law tends only to protect disclosures that are made internally. In other words, your first starting point has to be to make the disclosure, to blow the whistle to your employer directly. And if you go outside of the organisation, in particular to the press, but arguably even to, say, a regulator, then you might lose the protection that the whistleblowing legislation brings. If you are covered by the whistleblowing rules, then it's unlawful to dismiss you from your job, and it's unlawful to subject you to any detriment, which might involve disciplining you or demoting you or reducing your pay or suspending you. And really usefully, excuse me, in whistleblowing cases, if you've been dismissed, a special form of tribunal relief is available called interim relief, which enables you to apply to a tribunal. You have to do it very quickly, within 7 days of losing your job. And the tribunal has a super quick hearing, often within a further 7 to 14 days, and takes a view about the strength of your case. And if it's pretty good, if the tribunal says you might well succeed with this, then the tribunal can make what's called a continuation of employment order, which means you have to go back into employment with your employer, and your salary keeps getting paid, and all your benefits are paid, and that continues right until the end of the case. And at present, because of the backlog in tribunals, that could be 12, 18 months, 2 years even. And at the end of it, if you lose your case, you get to keep all the pay that you've had in the meantime. So it's an absolute nuclear weapon in the arsenal of employment lawyers. Really useful to be aware of, but you need to act really quickly if you're dismissed for whistleblowing.
Thank you, Paul. the next question is, if you don't mind, Laura, it's regarding the Equality Act 2010. I'll just come to that, but we've had a couple of questions from students, and always great to have students on board, and obviously the future of social work. It seems to be questions around marking and lecturers and for submissions. You know, behind the scenes, we've been looking at the questions and trying to determine an answer, and it seems the best way forward than trying to debate that tonight is it seems to be an academic institutional issue. So really anything related to marking and lecturers, if you have a student rep, you should maybe raise it at the programme board of the university, ask for it to be minuted and actually get a reply to take it further, because it's not actually an employment one. But we can maybe look at that later on, but that was just some guidance there. So thanks for submitting it, and thanks for being part of the webinar. So the question which just came in, Laura, is what is harassment under the Equality Act 2010?
Okay, yeah, the harassment is basically unwanted conduct, but the unwanted conduct has to be related to a protected characteristic. So under the Equality Act, there are a number of protected characteristics that are listed. These are, and I'm not going to lie here, I have the list in front of me because I always forget one. So we have age, disability, gender reassignment, marriage and civil partnership, pregnancy and maternity, sex, race, religion or belief, and sexual orientation. So any of those characteristics are what are defined as protected characteristics under the Equality Act, which means that there's certain conduct towards those people with those protected characteristics that is protected or prohibited, basically. One of those forms of conduct is harassment as defined under the Act. So as I've said, unwanted conduct relating to that characteristic. It's defined under the Act as something that would violate someone's dignity or create a hostile, intimidating or offensive environment. So, you know, practically speaking, we could be talking about inappropriate sexual comments towards women, racist comments, you know, offensive comments, that make people feel uncomfortable. For example, comments about trans people that are directed towards the trans person within the work environment and create that environment where someone feels uncomfortable working. And that is, you know, that is unlawful according to the Equality Act. It is harassment is a form of discrimination under the Equality Act. If anyone is suffering anything to that effect, yeah, please get in touch and get that advice and support straight away, because it shouldn't be happening, and it needs to be dealt with, you know, as soon as possible, really.
Thank you, Laura. Anything you would like to add to that, Paul? Two small points. Laura's covered the bulk of it. I'd add this. The way that the legislation is framed is that harassment takes place if the purpose or effect of what the harasser does gives rise to the sort of consequences that Laura's just described. And that's really quite important, because it's purpose or effect. So if you don't intend to upset somebody or interfere with their dignity or humiliate them, that's no defence to a harassment claim. If the effect of what you do is that in fact is what has happened to the victim, then that's sufficient for a harassment claim to succeed. And the second thing that I'd say isn't really about harassment under the Equality Act. It's more generally about bullying and harassment. And I think it's very commonly thought that the law will protect you from bullying and harassment generally. And it doesn't, or it certainly doesn't very well, unless you can identify one of the, is it 11 protected characteristics? I can never remember the whole list either, Laura, but unless you can identify one of those, age or race or disability or whatever, and say, that is the reason that I've been harassed, then the law does not provide a remedy directly for bullying and harassment at work. 20 years ago, it was suggested that there should be a Dignity at Work Act that would have created for everybody a direct complaint to an employment tribunal to allege, for example, that you've been bullied at work for whatever reason, maybe just because you didn't get on with your boss. You might both be the same age, both white, both male, not disabled, so there were no protected characteristics in play. But we all know that bullying and harassment happens at work without protected characteristics. And sadly, there is not a good remedy for that. The one way ahead in those cases tends to be to leave and try to claim what's called constructive unfair dismissal. And those claims are enormously difficult. 99.5% of them fail. So the short point is that there's a hole in the law, a lacuna, if you will, that means that lots of people who are bullied and harassed and made miserable at work are not protected as the law stands, because sometimes the law's an ass.
Thank you, Paul, and thank you initially to Laura. Just some housekeeping, just to remind everybody, keep sending your questions in, type them in the screen and keep them short and brief, and we'll do our best to answer them. We've got 25 minutes left, so still time for a few other quick ones. We've got a few already here, so I'll move to the next question. Before I start, I'm always incredibly impressed by the skilled advice and representation team and the quality of the answers and the service you get from SWU and BASWA, so I really have to get that in as well. So thank you once more. Question over to you, Paul, since Laura started. The other question is, how do I start a tribunal claim? What are the time limits, and what is ACAS's early conciliation? So is that okay for you, or do you want me to expand on that one?
No, I think I can tackle that. I can do so fairly shortly, actually. So the tribunal cases are subject to the shortest time limits of pretty much any type of legal process that we have in the UK. For example, if you want to make a claim because you've been injured in a car accident, you have a 3-year time limit for doing that. If you want to make a claim for breach of contract because somebody sold you a faulty fridge or whatever, you have a 6-year time limit as a rule for doing that. In the employment tribunals, if you want to make a claim for unfair dismissal or discrimination, or because your wages have not been paid, etc., you have a 3 months time limit. And it's not just 3 months, it's actually 3 months less a day. And that can be absolutely crucial. Today is what, the 7th of July. So if we're sacked today, the 7th, 3 months takes us to August, September, October, but it doesn't take us to the 7th of October. The time limit takes us to the 6th. And if you wait to the 7th to start your case, then your case will be kicked out. The tribunals have a very, very limited discretion to extend those time limits. But in 30 years doing this, I've seen that happen maybe once. The tribunals, as a rule, will say, put it in time or don't put it in at all. So if you can do it in time, so this is about getting advice early. If you're a member of the union, go and see the union as soon as you have an issue, and in particular if that issue is crystallized into something serious like a dismissal or discipline, or if there's harassment going on or whatever, talk as soon as possible to your union, get advice so that the time limits can be complied with. And if you need to take steps yourself to start a tribunal claim, then the first thing you have to do now for nearly every sort of tribunal claim is to lodge what is called ACAS early conciliation. So it's a simple process. If you search the ACAS website online, you'll find that there's a form you can fill in. You give very few details, your name and address, your employer's name and address, and you say, I want to make a claim against my employer. And ACAS can then try to conciliate, to come to an amicable conclusion between you and your employer before a tribunal case starts. And that can last for several weeks. I think it's up to 6 weeks now, in fact. Sometimes, of course, your employer won't engage with a process, in which case the thing can be truncated. At the end of the process, you get a certificate, what's called an EC, or early conciliation, certificate, and you need that certificate to start a tribunal claim. If you want to start a tribunal claim, again, you go online. If you search for employment tribunal claim form, it's all available online. A relatively straightforward process of filling the form in, but probably I'm saying that because I've done hundreds of them. I think it's much more likely to be terrifying if you're doing it on your own. It's a 15-page form, but as part and parcel of that form, you'll need to put in the reference number that you got from ACAS on your ACAS EC certificate. So that's the process. Act quickly, do it inside your time limit, participate in ACAS EC before you start a tribunal claim, get online and lodge your EC application, and subsequently and within the time limit lodge a tribunal claim, and again that's best and most easily done online.
Thank you, Paul. And Laura, is there anything you'd like to add to that question?
Just to reiterate Paul's point, don't miss the deadline, because if you miss it, they're highly unlikely to accept it.
Good. So thank you. And there's a question came in quite similar to that, but we'll maybe look at, there's been a few questions came in, and we'll do our best to, to get onto them if you're waiting for them to be answered. So the next question, Laura, if you don't mind staying with this one, it says, as we come out of lockdown, hooray, I think we're all saying, can a company insist that I continue to work from home?
Again, another very interesting COVID question, which I think we're going to start getting more of as we're starting to come out of the lockdown as it is. Although, who knows what guidance we'll have in a month's time. It's very difficult to know sometimes, isn't it? But I think one of the big impacts of COVID is that employers have actually realised that, contrary to what a lot of them believed before, their social workers can work quite effectively from home and work flexibly. And a lot of employers have realised the benefit of not having offices, because they cost lots of money and they cost, so that there are some employers that are having a real push towards getting social workers working from home more. Now, I think there's two ways of looking at it. Firstly, I think, it's good that employers are trying to look at flexibility for workers if that's right for the worker. The problem is, I think several people, social workers, have raised that actually it's the kind of job where you need that team communication sometimes, and to be able to talk to people and discuss cases and situations, or just sound off with your colleagues. And if there's no office and no team to do that with, it can be quite difficult and can add stress to the job. The other thing I think that is quite important to note is that not everybody has the facility to work from home. Not everybody, in fact, lots of people don't have spare bedrooms. They buy their house according to how many people live in that house. They don't have a spare room where they can have a desk and a proper setup. So actually, what is the employer going to do about facilitating that? If the employer is saying that they're going to be moving towards, working from home, effectively that might be a change of your terms and conditions of your contract. So that would need to be discussed. It would need to be discussed actually what they are going to do to make sure that your home environment is suitable for you to work. Do you need particular equipment, desks, monitors, etc.? There's all sorts of questions that I think need answering and looking at with your employer to make sure that they're doing what they should be. And so I think, again, it's one that would be worth exploring more with an A&R officer in terms of what can the employer be doing, and is it, if you're clear that actually working from home isn't for you, what that dialogue needs opening with the employer in terms of what the alternatives are, really.
Thank you, Laura. And Paul, was there anything you'd like to add to that?
I agree with all of that. I guess I want to turn it on its head a little bit and say that one of the questions that we're seeing very often now is not that my employer is insisting I continue to work from home, but what if I want to, under the new normal, continue to work from home, and I've done that successfully so far, then can I insist on doing that if my employer says, no, I want you back in the office? And there's a whole host of questions that flow from that. There's a right, of course, at present to request flexible working. So if your employer says, I want you back in the office, the first thing you can do is lodge an application for flexible working to say, I'd like to work flexibly, and that might involve a changing hours or a change in location or whatever. But the right at present is only a right to work flexibly. A right to request working flexibly. And as the name suggests, you can make the request, but if the employer says no, then that's the end of it. And I see the government has said in recent weeks that it intends, allegedly, to expand the flexible working framework to give people a greater right to work flexibly. We'll see what comes of that. In most other respects, I'm not seeing much flexibility in the employment field coming from this government, so I'm sceptical about it. As matters stand, it'll be a matter for negotiation. Get advice from your union again, put in the application to work flexibly if that's what you want to do, and your union can support you with that.
Thank you, Paul. And I'll stay with you. In fact, I'll move to Laura for the next one, if that's okay, Laura. So we're actually getting through lots of questions, and we'll try to stay brief for these. I think we've got another 4 or 5 questions still to get through, which is great actually. It'll take us to something like 16 or 17 questions we would have answered tonight. So Laura, the question is, my employer has given me a negative reference and I have lost a job offer as a result. Is there anything I can do about this?
Yeah, I mean, I think with references, there is a bit of a myth that I still hear people say quite often nowadays, is that an employer can't give you a bad reference. They're not allowed to give you a bad reference. That actually isn't true. But what the law is and what the law states is that an employer has to give a factually correct reference. So you know, and I've seen situations that our A&R team quite regularly kind of advise and try and support people with getting an accurate reference and a fair and accurate reference. I've seen situations where a manager and an employee, for whatever reason, haven't got on. The manager took a dislike to somebody. They've gone off to get a new job, and then they've had this reference that states there was practice issues or issues with the performance, but nothing's ever been raised with that social worker previously. There's been nothing discussed in supervision, no disciplinary or capability processes. That kind of thing would be unlawful, because actually, if that's not factually correct, if they can't evidence the fact that there were any performance issues, they shouldn't be providing that reference. In terms of the remit legally to be able to pursue a reference if it was factually incorrect, again, bizarrely enough, references aren't generally covered under employment law, which seems a real strange thing, and I think that's quite difficult to get your head around actually. But they actually are covered under civil law in terms of them being a potential defamation of character, or what's called a negligent misstatement. So to be able to pursue it, you would really need to go down the civil court route. There is an exception to that, and that's if the reference has been provided in a discriminatory way. So if there's been discrimination happening in their employment and we can prove that the reference is discriminatory, discrimination is employment and is covered under employment tribunal jurisdiction. So, I mean, I think for me, what I tend to say to people and advise people is, if you can get a copy of the potential reference that your employer is going to provide before it goes to that prospective employer, then that helps for you to ensure that if there's any difficulties, anomalies with that, then you can liaise with your employer and try and rectify that, you know, immediately before the damage is done. Because once that reference is gone, that it's there, the prospective employer has seen it. So that's the first thing I advise people to do. The second thing I say is, if you have had a negative reference, we do have a guidance sheet that we can provide to people in terms of trying to negotiate with employers to get that reference changed to make it factually correct and fair. Get in touch with our A&R team, and our admin team will send that out to yourselves. If you're still having difficulties and not being able to get that reference, our A&R team can sometimes try and support with that in terms of contacting the employer to try and negotiate a more reasonable and factually correct reference. We aren't always successful, but we have had some successes in terms of getting that reference to be a fair and factually correct one moving forwards. And it is always worth trying to go down all of those routes first before looking at pursuing legal claims, because they're lengthy, they're stressful, they're time consuming. If you can avoid having that reference in the first place by trying to get a copy of it before it's provided to the employer, it saves all of that stress.
Thank you, Laura. And Paul, anything you want to add to that regarding the negative reference?
That's a really good reply from Laura, covers pretty much everything. I guess I'd add this, that one of the biggest problems with these cases is finding out what's been said. And by said, I mean verbally said, because lots of employers will sidestep the whole issue by picking up the phone, speaking to the previous employer. And if they say on the phone, yeah, well, that person was a trouble causer and you shouldn't employ them. How do you prove that? Unless you've got somebody at the new putative employer who's prepared to spill the beans. So evidentially, these cases can be really difficult. And as Laura says, for reasons that are not at all clear to me, the only way realistically to pursue them is in the county court. And that means legal costs, which can run into tens of thousands of pounds. Trade unions often won't support those cases for lots of good reasons, largely because of the evidential difficulties I've said, together with the enormous cost. So I've no good news to give about it, really. And Laura's really practical approach there about trying to engage with the A&R team to see if they can do something more practical than litigation. I'd absolutely recommend that, because I think by the time you get to lawyers on these things, you've already lost.
Thank you, Paul. And I'll maybe stay with you, Paul. There's a couple of more questions regarding our COVID situation. This one's regarding lateral flow testing of staff, and it's really about the legal position of being insisted to undertake lateral flow testing. So I don't know if there's opinion on that, Paul.
Kind of goes back to the vaccine and masks point that Laura and I talked about earlier. I think certainly if we get to a point where the courts and tribunals are going to say that you could insist on vaccination, then you're certainly, I think, going to be able to insist on testing on the basis that it's less invasive. I think there was this question of whether or not we talked about earlier whether or not somebody could require it during holidays, which seems to me bizarre that an employer would want you to do that when you're not at work. But saying to people, we want to ensure that you're safe so that you're not infecting colleagues, I think there are reasonable grounds probably for an employer to be asking for that sort of assurance. And again, that might depend on the setup, the sector, whether people are exposed to other people in close proximity, whether it's in the healthcare environment and similar to that.
Thank you, Paul. And a question for you, Laura. There's about 3 questions left. This one is, what is the provision, and if any, under law that the employers and social work provide to enhance and maintain health and well-being and managing workplace stress for social work frontline staff, including management? So again, they're asking, what is the provision that the employer and social work provide to enhance and maintain health and well-being and managing workplace stress for social work frontline staff, including management?
I mean, I think there's several elements to that question, really. In terms of what provisions employers provide, from a practical point of view, it does vary from employer to employer in terms of what provisions we see employers provide. As an A&R team, we tend to see the employers that aren't providing so much in terms of enhancing health, safety, well-being, because actually, if the employer is doing that and trying to really promote the employee well-being, we're probably not going to hear about that, because why would they come to us to talk about that? I mean, I think certain employers have a lot of the employee wellbeing schemes that include particular health benefits, and counselling is one of the things. Most employers that I have represented people with do have those wellbeing schemes, and staff can access counselling. In terms of the law around that, there isn't any legal duty for employers to provide those wellbeing schemes, but what the employer does have a duty of care towards, and a very well established duty of care towards, is to maintain a duty of care towards the health and safety and well-being of the staff that they're working for. Now, that health and safety does include workplace stress and stress at work, and I think that's really important for people to note, that actually there is a duty for their employer. If you raise an issue with workplace stress and the employer doesn't do anything about it, they should be doing something about that. They should be recognising that and trying to minimise that workplace stress to make it a safe environment for staff to be working in. Social work is always going to be a stressful job. I cannot sit here and say that the employer can make it an unstressful job, if that's even a word, because it's social work. But the employer does have a duty to be ensuring that caseloads are manageable, and if people are struggling, they should be exploring that and looking at things like stress risk assessments are quite commonly used nowadays in terms of what can we do to support this staff member who is struggling with this stress, because ultimately stress has a severe impact on your health and well-being and can often result in people ending up with time off sick. So it's in the employer's benefit to try and minimise that stress. So there is a duty of care there from a legal point of view.
Thank you, Laura. Paul, a few questions left, but is there anything you want to add to that that's urgent?
Just worth saying that there's a commonly held view that if you suffer a severe stress at work, then you might be able to make a claim for compensation for personal injuries, in the same way, if you're injured at work in a trip, or your hand is caught in a machine or whatever, and that's true. Stress at work is an injury in the sense that you can make a claim for it, just as if you suffered from dermatitis because you were exposed to some toxic chemical at work. But, and this is a really big but with a capital B, those claims are really, really difficult to pursue. And in fact, most lawyers don't even pursue those claims on what are called no-win, no-fee terms these days, because so few of them succeed. So I think it's just useful to take that moment to dispel the myth. Stress injury at work is a real thing, but turning that into a compensation claim is very difficult indeed.
Thank you, Paul. And two last questions. A member's asking, Laura, this is just a quick one for you. They're asking what support can they expect from the Social Workers Union if I'm involved in I'll put my teeth in, disciplinary matter. So what could they expect?
Well, the first thing I think it's important to highlight the eligibility criteria for representation. So someone has to have been a member for 3 months to be able to get representation from us, and that's a common thing with most trade unions. There is normally a period under which somebody is entitled to that representation, and it can't be a pre-existing issue. We don't represent on issues that are pre-existing the membership and in that first 3 months. Having said that, from day one of your membership, you're entitled to advice from our team. So if you are subject to a disciplinary and it's occurred within the first couple of months of you joining us, or actually has happened before you've joined us, from day one you're entitled to a duty call from our team, which is normally around a 20-minute appointment, where we can offer you advice on your situation and what to expect from a disciplinary process, etc., etc. If you've been a member for 3 months or more, you can expect advice from our team from day one of this, and probably representation. We will attend investigation interviews with you so that you've got that support from us, and we will attend disciplinary hearings with you and help you to represent your case, and question people at hearings, etc., etc. We will be involved in all of that process from day one, and that may well involve us emailing your employer to raise issues as the process is ongoing and challenging that. So pretty much full support. As long as you're eligible for that representation, we'll support you as much as we can with that.
Thank you, Laura. And I've had a few minute warning. We're coming to the end now, so thank you for all the skilled people behind the scenes. So Paul, maybe we'll finish with this. I suppose it's a kind of positive one that we're able to book holidays again, and the question is asking, during lockdown, can my holidays be carried over, and how much entitlement can I carry over? So hopefully you'll have good news to share with everyone, or maybe not, but we'll finish with that question. So again, they're looking at can my holidays be carried over, and how much entitlement can I do? So you've got about 2 minutes to do this, Paul, if you can.
Right, I'll be quick. No. So last year the law was temporarily changed to say that if, because of COVID related reasons, you were unable to take all your holiday entitlement, then you could spread up to, I think, 4 weeks into 2021 and 2022. That's not been repeated, to the best of my knowledge, this year. So people who carried some over last year can still do it this year, can still carry some of that into next year, but otherwise there's no automatic right to carry over holidays. The rule is use it or lose it. Your contract of employment, however, may say different. And if your contract says that you can carry over, or if you can persuade your employer to agree with it, then great, do that. That'll let you carry over. And let me just say on a related note, and this could be relevant for all sorts of reasons, especially in relation to COVID, if for whatever reason you've got a holiday booked and you can't enjoy it because you're sick with COVID or anything else, then there's a really useful European law case called Pareda that says that you're entitled to ask your employer to reschedule that holiday for another time when you can enjoy it when you're properly fit. So be aware of that too. And that was less than 2 minutes, John.
There you go. Thank you. And Laura and Paul, thank you once more. We're hoping we'll have another webinar in maybe 3 months' time. And as always, we said that you can contact the SWU and BASWA advice and representation team if you're a member to expand on questions. So thank you. I will like to also thank behind the scenes, that not often seen, but certainly all the hard work from Sean and also Lisa and Jane. So thank you. And I'll just leave you with one point: is it coming home? So I'll leave you with that point to ponder on. Hopefully you'll have a lovely evening, and good night to you. Goodbye.
Bye.
Bye.